Legal dictation at the speed of 140 words per minute from Shekhar Shorthand magazine. A Supreme Court judgment. 1, 2, 3, start. However, it will be open to the parties on both the sides to take all available contentions before the High Court on the point of catch up. In terms of the liberty granted by this court, the appellant moved the High Court in review. The review petitions, as stated earlier, were dismissed on 21st March 2018. Agreed by the judgment of the High Court in review and the original judgment in the writ petitions, the appellant moved this court afresh under Article 136 of the Constitution. During the pendency of these proceedings, the appellant has instituted miscellaneous applications along with an interlocutory appeal. By the miscellaneous applications, the appellant has sought a clarification of the order dated 12 December 2017 so as to seek a specific permission from this court to move afresh if the review were to fail before the High Court on 28 November 2018. Notice was issued on the miscellaneous applications. 14 SLPs numbers 8769 to 71 of 2018 was filed against the judgment in review. SLP civil numbers 14041 to 43 of 2018 were filed against the judgment in the writ petitions. A preliminary objection has been taken to maintainability of the special leave petition by Mr. R.P. Bhatt, learned senior counsel appearing on behalf of the first respondent. Mr. Bhatt urged that as a result of the order of this court dated 12 December 2017, all issues other than the application of the catch-up rule were given up when liberty was granted to the appellant to move the High Court by way of review. Once the review was rejected by the High Court, the following consequences must, according to the submission, issue. 1. A challenge to the original order of the High Court allowing the writ petitions is barred in the absence of liberty being granted to the appellant to move afresh after the review was dismissed against the original order assailed in the special leave petition. 2nd. A challenge under Article 136 of the Constitution solely against an order on a review petition is not maintainable. In support of the submission, certain decisions of this court have been relied upon which would be adverted to hereafter. The first task of this court is to construe the order dated 12 December 2017, as the order indicates the grievance of the appellant was that though the issue of the catch-up rule was raised before the High Court, it had not been considered. A two-judge bench of this court consisting of Honorable Mr. Justice Kurian Joseph and Honorable Mr. Justice Amitwa Rai, which heard the special leave petitions, observed in response to the submission that if that be so, it is for the petitioner to pursue his remedies available to him under law on that issue. This court permitted the special leave petitions to be withdrawn without prejudice to such liberty, leaving it to open to the contesting parties to take up all available contentions before the High Court on the issue of catch-up. The bench observed that we make it clear that we have not considered the matter on merits. What emerges from the order dated 12 December 2017 is that first, liberty was granted to the appellant specifically to pursue the remedies available in law on the grievance that the issue of catch-up, though raised, had not been considered by the High Court, and second, this court had not considered the matter on merits. The reservation of liberty to the appellant to adopt a suitable remedy in law to pursue the grievance that a submission which was urged before the High Court had not been considered would evidently be a reference to the remedy by way of a review. It is well settled that if a submission which has been urged before the High Court has not been noticed or considered, it is to the High Court that the aggrieved litigant must turn for the ratification of the record. But apart from this, the observation in order dated 12 December 2017 that this court had not considered the matter on merits is of crucial significance. The purpose of that clarification was to ensure that the issues which were raised in an event with regard to the catch-up rule were entirely open to be urged before the High Court in the first instance, and thereafter, if the appellant were to be aggrieved in further proceedings before this court, the above observation of this court was not merely intended to keep the issue of the non-consideration of the catch-up rule open to be urged before the High Court. That this issue was kept open is evident from the last part of the order dated 12 December 2017, which specifically keeps open the contentions of the parties to be urged before the High Court. In addition, the order of this court carefully enunciates that we have not considered the matter on merits. In view of this clarification, it is impossible to accept the preliminary objection that a recourse to this court is barred apart the High Court decided the review petitions. To take any other view would effectively deny access to justice to the appellant. Evidently, the grievance of the appellant was not considered by this court on merits on 12 December 2017. To adopt a construction which would deprive the appellant of the remedy of moving this court after the decision of the High Court in review would lead to an egregious failure of justice. Such a construction must be eschewed. We would like to note an important aspect of the matter here which reflects on the bona fides of the appellant. The appellant moved a miscellaneous application on 22nd November 2018 by way of abandoned caution for seeking a clarification of the order dated 12 December 2017. The appellant sought a clarification to the effect that upon the disposal of the review petitions by the High Court, it would be open to challenge the order in review as well as the original order before this court. Stop.